And we are here for a final pretrial conference. The court has been presented with a nollie pros dismissing the case without prejudice for further prosecution not in the interest of justice at this time. The case may be charged at a later date. Is there any qualifications as to when the case could be recharged?
No, Your Honor, there's an understanding between the parties that if he continues to cooperate with CPS, which I've gotten a glowing letter from CPS that we're not going to recharge it unless there's another incident.
All right, Mr. Hartel, are you in agreement with that?
I'm in full agreement, Your Honor.
I guess the concern the court has is what constitutes compliance with CPS. Is there a court order ordering him to comply with CPS?
No, he's complying with a safety plan. I think that involves attendance at counseling. He may have already completed that.
One of his bond conditions is complete.
Is there currently a CPS case open now, or is it, when I say case, is there a probate case open, or is this just strictly compliance plan right now? You know,
I think it's just a safety plan, that's my knowledge. But
Mr. Hartel, are you aware?
That's my knowledge.
Mr. York, are you, I mean, you do have the right to have a trial. You've invoked your trial rights. Are you okay with this dismissal?
yes.
You understand that if it appears that if at any point someone decides you're not in compliance with CPS, this case could be brought back. Do you understand that?
Yes.
Okay. All right, the parties all in agreement. I will go ahead and sign the dismissal. And the parties can get a copy of it at the front window. Council, do we have anything else ready to go?
I think we can go forward on Isaiah Eisenhower.
Okay. Okay, Mr. Eisenhower. Court calls the people of the state of Michigan versus Isaiah David Eisenhower, case number 252869 ST. Appearances, counsel.
Lawrence on behalf of the people.
Robert Hartel for Mr. Eisenhower, who joins me at the table.
Thank you. You may be seated. We are here for a final pretrial conference. Is there any resolution?
There is not, Your Honor. We were hoping, as well as the defense, to ask for a couple-week adjournment. We're hopeful that the defendant can work on some things and maybe provide our office with some documentation, and hopefully we will have a resolution too.
Mr. Hartel.
That is accurate. I've discussed it with my client and would also be on board with it if the court allowed.
What type of things are you looking for him to do?
We're hoping he can enroll in a driver's ed class, given the nature of the charge, and we can provide some documentation that he's completed that.
All right. Mr. Eisenhower, have you heard what the attorneys have said?
Yes, I have.
And are you in agreement with the request for adjournment?
Yes, I am.
All right. Then based on that, the appearance of a stipulation, we will go ahead and we will adjourn today's final pretrial until honestly, it's probably be the next final pretrial date. So, which is the 18th, if I recall correctly.
September 18th.
September 18th. Mr. Eisenhower, just a reminder that your bond conditions continue and you can go up to the front window and get your next court date. All right, thank you. Is there anything else? All right.
Who?
McKinney. This is case number 252469 OD, the people of the city of Cadillac versus Colin Shane McInerney. We are here for a couple of things. One is a final pretrial conference, and the other is a bench warrant for fail to enroll in alcohol and drug testing disorder on July 1st and July 2nd. The defendant was placed on a term of bond in this matter, and the conditions were that he were to enroll in, that he was not to consume any illegal controlled substances, including recreational marijuana, alcohol, and be subject to random testings for both. Defendant was tested today and has tested positive for THC. Is there any resolution to either one of these issues we're here for today?
For the bond violation, I believe my client intends to plead guilty with explanation. There is no resolution for the case in general.
Is that your understanding, Ms. Lawrence?
It would be me, Your Honor.
I'm sorry.
Yes.
Mr. McInerney, is that your understanding of what's happening today?
Yeah.
Now, a couple of things I want to go through with you. Most importantly, that this is the last day that you have to enter a plea agreement in this case. Moving forward, we're moving as if we're going to go to trial. So there's only a few things that could happen. One is that the case is dismissed in its entirety. Two is that you plead guilty. Mr. Carnes?
If I may, I think it's fair to disclose, I just received blood results from the Cadillac City Police Department this afternoon, and I've just shared those with the defense. I think it would only be fair that 2 weeks in light of that.
Ms. Ejimera?
I have no issue with the adjournment.
All right, then scratch that. What we'll do is based on a stipulation today, the fact of, I don't want to say late discovery because I know the lab runs behind. But having discovery just turned over today, we will go ahead and we will reset the final pretrial to next month's final pretrial date, which is the 18th of September. That leaves us with the bond violation. And it's my understanding, Mr. McInerney, you plan to enter a guilty plea to that violation. Is that accurate?
Yeah, tactical explanation.
Okay, but, all right. Just a moment here. Let me get caught up with my notes. I don't remember if I swore you in or not, so I'm going to go ahead and do that again. Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Sir, is it true that you failed to enroll in alcohol and drug testing as ordered on July 1st and July 2nd of this year?
Yeah, I failed to report those because I've never been on bond before, and it's a random testing, and I thought that they would get a hold of me because it was random. I wouldn't know when to go in. I didn't know I was supposed to go the very next day. I thought I was going to be contacted when I didn't fit, so
Give a drug test.
I thought I was going to be contacted each time that I was needed to be drug tested, and I didn't understand it.
Ms. Ejimera, Mr. Carnes, please approach.
All right, let's talk about that. This session in front of Judge Corey J. Wiggins brought us a little bit of everything. Dismissals, adjournments, bond conditions, and one defendant who learned the hard way that random testing doesn't mean someone calls you first. The judge kept a steady hand throughout, making sure each matter was handled with clarity and fairness while still moving the docket forward. What stood out most was his ability to balance patience with firmness, giving defendants room to speak, but reminding them when deadlines and conditions weren't negotiable. That's a tough line to walk, and he did it without raising his voice or showing frustration, even when explanations strayed into, "I thought you'd call me" territory. On the defendant's side, Isaiah David Eisenhower presented as cooperative and straightforward. Both attorneys asked for a short adjournment so he could enroll in a driver's ed class, which directly tied to the nature of his case. It was a simple, constructive plan, and Eisenhower agreed without hesitation. His body language and tone suggested someone who wasn't looking to fight, but to demonstrate good faith, and the court seemed willing to give him that shot. Colin McKinney's situation, however, was less polished. He admitted to missing required drug and alcohol testing, explaining that he misunderstood how random testing works. It wasn't defiant so much as naive, but the admission also came alongside a fresh THC-positive test, which undercut the honest mistake narrative. His demeanor wasn't combative. If anything, he looked a bit overwhelmed. But Judge Wiggins still had to emphasize that these conditions were clear and binding. As for the attorneys, the prosecutors and defense counsel were generally professional and aligned on procedural points. In Eisenhower's case, both sides came to the table with a shared plan, which helped things run smoothly. In McKinney's matter, the defense at least tried to frame the bond violation as a misunderstanding, while the prosecution dropped in a surprise piece of late lab evidence. To the court's credit, instead of pressing forward, Judge Wiggins acknowledged that fairness required an adjournment. It wasn't a flashy moment, but it showed how the legal system is supposed to work. Both sides given equal footing, even when one file comes in late. The courtroom atmosphere shifted depending on the case, measured and cooperative with Eisenhower, a little heavier with McKinney, but it never tipped into chaos. Judge Wiggins' steady pacing, occasional clarifying questions, and matter-of-fact tone set the rhythm. Even when the explanations felt a little flimsy, he kept things professional and grounded. There wasn't much humor in this session, but there was a sense of balance. Defendants got their say, counsel had their chances to adjust strategy, and the judge made sure the record stayed clean and fair. In the end, this hearing showcased how the system often works in practice. Not dramatic showdowns, but procedural check-ins, reminders of responsibility, and a judge making sure each step follows the rules. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.